my lord, is I'm going to go straight to Coburn College, and what I'm going to do, if I may, is feed off Coburn College as I go through it to make submissions on the points that arise more directly in this case. In other words, in terms of the contract.
So you're going to use that as the sort of spine for the submissions?
Yes, I thought I would. There are obviously other cases to which I'll take you, but very shortly. Can I take you to Coburn College? It's in Divider 8 of the First Authorities. My learned friend took you to the Limitation Act provision. I will take you, if I may, just quickly to page 132, to the footnote, just to remind you, halfway down the left-hand column, that we're also in the under the umbrella of the Solicitors Act 1843, section 37, where it is provided no attorney or solicitor, etc., shall commence or maintain any action or suit for the recovery of any fees for any business done by such attorney until the expiration, or solicitor, until the expiration of 1 month after such attorney or solicitor shall have delivered unto the party to be charged therewith, or sent by post to or left for him at his counting house, office of business, dwelling house, or last known place of abode, a bill of such fees, and which bill shall either be subscribed with the proper hand of the attorney, etc. One might say that that is a fairly clear indication that a bill is required to be delivered, and it is only after the bill has been delivered that an action may be commenced or maintained. And Lord Esher, the Master of the Rolls, at page 134, sets out what is now the well-known and established principle at the foot of the page. And one is there talking about the right to payment, not the right to enforce the right to payment. And if one turns over the page...
Sorry, I'm on 134 and it's talking about bringing an action, isn't it? Right to payment. I'm so sorry.
I'm so sorry, my lord.
Yeah, no, it's my fault.
No, I was doing it too fast.
You were.
And thereon he can once bring his action. But of course, if one defers the time for bringing the action, one can't bring the action.
Yep.
Then he goes on, and this is why Coburn College is of more general application. It's not just focused upon the Act or solicitors. It says before any enactment existed, this is actually about solicitors, with regard to actions by solicitors for their cost, a solicitor stood in the same position as any other person who has done work for another at his request, and could sue as soon as the work which he was retained to do was finished, without having delivered any signed bill of costs or waiting any time after delivery of such a bill. Then to what extent does the statute alter the right of the solicitor in such a case, and does the alteration made by it affect or alter the cause of action? It takes away, no doubt, the right of the solicitor to bring an action directly the work is done, but it does not take away his right to payment for it, which is the cause of action. The statute of limitations itself does not affect the right to payment, but only affects the procedure for enforcing it in the event of a dispute or refusal to pay. Similarly, Section 37 deals not with the right of the solicitor, but with the procedure to enforce that right. And we would say that the way to approach this contract, this agreement, where we have provision for an invoice and payment within 90 days of an invoice, is exactly the same way. The invoicing provision deals not with the right of CCI to payment for the services that CCI has performed, but rather deals with the right of CCI to enforce its right to payment. It cannot enforce its right to payment unless and until it has delivered an invoice, and only then after the expiration of 90 days thereafter. And it does not provide that no solicitor shall have any cause of action in respect of his costs, or any right to be paid till the expiration of a month from his delivering a signed bill of costs, but merely that he shan't commence or maintain an action, etc. It assumes that he has a right to be paid the fees, but provides that he shall not bring an action to enforce that right until certain preliminary requirements have been satisfied. And we say mutatis mutandis, if one's allowed to say that, in this case. if one looks at the invoice in this case, one sees that what the invoice says, and this is somewhere at the end of in divider 11, it's at page 113, electronic 111 paper. And it is headed Responsibilities of CPA. It's nothing to do, and is not headed Right of CCI. And what it says is all invoices submitted by CCI will be paid within 90 days, not on the expiration of 90 days, but within 90 days. In other words, at any time in the period of 90 days. And that, in our respectful submission, assumes and is predicated upon, and the judge concluded that this was right, upon there being in existence already a right to payment vested in CCI. It is not a right to payment which is vested in CCI within 90 days after invoices. And it says if funds, and that's the condition. That's a condition for the payment, but is not a condition for the right to payment. And it says by submission of the said invoice, and we've got comma issue, by CPA to a bank account designated by CCI. And it's a rhetorical, it's rather an unattractive way of putting it, but it would be remarkable if that provision were equivalent to the special term contemplated as required by Lord Isha, the Master of the Rolls in Coburn and College, to overturn and displace the general rule of law. One might say that Coburn College is an a fortiori, or ours is an a fortiori case. In Coburn College, there was an explicit provision, statutory provision, doesn't matter whether it was contractual or statutory. There was an explicit statutory provision that the solicitor could not bring an action to recover their fee unless and until they had delivered a bill of costs. Our case doesn't even express that. All it says is payment is to be made within 90 days. Let's imagine that our case said that it was a condition that before CCI could enforce, it could recover its payment, it had to deliver a bill or an invoice and wait 90 days thereafter. Well, if what is in Coburn College wasn't a special term, and it wasn't, how could that be in our contract? It wouldn't be. And the term in our contract is far less explicit and far less positive and direct than Section 37 of the Solicitors Act. And then Lord Isha goes on. If the solicitor has any other mode of enforcing his right then by action, the section does not seem to interfere with it. For example, for instance, if he has money of the client in his hands, not entrusted to him for any specific purpose, there is nothing in the section to prevent his retaining the amount due to him out of that money. Likewise in our case, if CCI had money from CPA which hadn't been allocated to this agreement, there would have been absolutely nothing to prevent CCI, having done the work, even before rendering an invoice, from deploying those assets or that money towards the reduction of the debt owed to it by CPA. If that's the true construction of the section, it doesn't touch the cause of action, but only the remedy for enforcing it. And then the Master of Rolls refers to his own definition in Reed and Brown, which is every fact which it would be necessary for the plaintiff to prove if traversed in order to support his right to the judgment. And he says, the plaintiff, in order to make out a cause of action, must assert certain facts, which if traversed he would be put to prove. And then he says this, in former times, if he failed to assert any of those facts, his declaration was demurrable as showing no cause of action. If he asserted those facts and they were traversed, it lay upon him to prove them. If any of them were not traversed, he need not, of course, prove them. Now, in our case, all that was required, or all that is required for the cause of action, is that CCI says there is a contract I was requested to perform services in consideration of payment. I performed those services. Those services are of value and they are worth $1 million, and therefore I'm entitled to payment. That is all that needs to be established and asserted for the cause of action. Then if one goes on about 7 lines down, if the plaintiff alleges the facts which, if not traversed, would prima facie entitle him to recover, then I think he makes out a cause of action. Similarly in our case. Applying that to a case like the present, when the plaintiff had completed the work under the old course of pleading alluded to by my brother Lopez, he could have brought his action declaring for money payable for work and labour done at the request of the defendant. And if the defendant made no answer to that claim, he would have been entitled to recover. The defendant could not have demurred the plaintiff's declaration, which would have shown a perfectly good cause of action. And unless the defendant set up something to defeat the claim, the action would have been maintainable. For example, the defendant, well, it goes on to say, therefore, as soon as the solicitor had done the work, he could have maintained his cause of action for work and labour. The defendant might plead that no bill of costs had been delivered, but that would only be by way of answer to a case which constituted a good cause of action. Similarly in our case, let us say that there was no invoice, but CCI had brought its cause of action. Well, it is only if CPA then asserted by way of defence, you haven't delivered an invoice, or if you have, 90 days have not elapsed. If CPA did not do that, that was a complete cause of action. In fact, it was a complete cause of action already. But if CPA did not do that, CCI would be entitled to judgment. For these reasons, I think that the cause of action in this case, to use the language of the statute van, was given accrued full and income the moment of the work which the plaintiff was retained to do was completed. Now, Lord Justice Lopez, very briefly, in the middle of the next page, 137, he says, it was contended for the defendant that the cause of action in this case arose as soon as the work was completed. I am of the opinion that that contention is correct for these reasons. And then this is a general observation with regard to solicitors, but it applies likewise to all service providers. Before the passing of any enactment with regard to actions by solicitors of costs, immediately upon the completion of work done by a solicitor, a debt arose for which an action could be brought without delivery of any bill of costs. And then he refers to the old rules of pleading. The solicitor would have sued in indebitatus assumpsit, in other words, a form of contractual debt, or on a common money account for work and labour. If the defendant had pleaded merely never indebted, and the case had gone to trial on those pleadings, the cause of action would have been said to have arisen as soon as the work was done. If the defendant intended to raise any defence on the ground of non-delivery of a signed bill of costs, he must plead that such a bill had not been delivered. The delivery of the bill formed no part of the plaintiff's cause of action. Similarly here, the delivery of the invoices, it's not a condition precedent to the accrual of the right to payment. It does not form any part of the plaintiff's cause of action. Upon proof that the work had been done, prima facie, the plaintiff was entitled to recover. It was for the defendant to set up by his pleading that no bill had been delivered. How then can it be said that the cause of action is not complete before the delivery of a signed bill? If that were so, it would have been necessary for the plaintiff to allege in his declaration, etc. And then on the next page, Lord Justice Lopez refers to section 37. It assumes that there is a cause of action merely to postpone the bringing of an action. Similarly, in our case, there is nothing in the section, so far as I can see, inconsistent with the view that the cause of action arises when the work is completed. Similarly, in our case, the provision for an invoice is not in any way inconsistent with the view that the cause of action in the normal case, and this is a normal case, arises when the work is completed. Then it is said it was urged that if this construction were adopted, a solicitor would have a shorter time during which he may abstain from bringing his action, work done in the rest of Her Majesty's subjects. That may be so. But on the other hand, and this is where Lord Newburger picks up, this is where all the other judges pick up, if the plaintiff's contention is correct, the solicitor may abstain from delivering his bill for 20 years and then at the end of that time he may deliver it and sue after the expiration of a month from its delivery. It seems to me that that would be a very anomalous and inconvenient result. And that's the genesis of all the judges who have thereafter said that clear words are required before a contract, or indeed a statute, but a contract will be construed as giving complete control to the creditor over the beginning of the running of time for limitation purposes. And it seems to us, in our respectful submission, that that would be a very anomalous and inconvenient result. And if someone had come along, if my learned friend had come along to Lord Justice Lopez and said, well, it's highly unlikely that a solicitor would delay or defer rendering his bill, I would imagine, given the tenor of the judgments of this Court of Appeal, that Lord Justice Lopez would have said, well, that is nothing to the point. The principle is the principle. And then you have Lord Justice Chitty.
Well, before you leave Lord Justice Lopez, I'm enjoying the last sentence of his judgment. I think that's a process that ought to be reinstituted.
Yes.
I think the idea of checking what somebody meant, who doesn't have to be sitting in the court, save an awful lot of argument sometimes.
Well, I'm sure you've had a very quiet word amongst yourselves about this case, and therefore I'll leave you, in your bravery and courage, to mention this in your judgment.
On we go.
But Lord Justice Chitty, the object of the statute of limitations was to afford a certain amount of protection against stale demands. I say to afford a certain amount because the statute doesn't bar the debt, but only takes away the remedy by action. And that's quite a telling remark, because he says the statute therefore makes a distinction between the action and the cause of action. And that is exactly the distinction, not only that the statute of limitations makes, but also that the principles of law make applicable to when a cause of action accrues in relation to a service provider. And if one turns the page to one...
So the action, namely the enforcement.
Exactly. And that's a distinction which is thereafter in fact drawn, as I recall, by Mr. Justice Eyre in Hurst and Dunbar. And in fact by Mr. Justice Jacobs when he sets out, I think, the principles in his first instance judgment. And 139, about 5 lines down, the statute of limitation in no way affects the cause of action, which is money payable for work done, but only postpones the right of action upon it for at least 1 month from delivery of the bill. Just substitute bill for invoice and put in 90 days instead of 1 month, and that is this case. My brother Lopez has referred to Bull and Leek on pleading. I will refer to an older work on the same subject, namely Chitty on pleading. Lord Justice Chitty is the grandson, in fact, of Chitty on pleading, who was Joseph Chitty. And for your reference, he was also the nephew of Thompson and Joseph Chitty, the younger, who were the authors of Chitty on Contracts. And as I said to my Lord Mr. Justice Jacobs, and I'll say to you, it really ought to be therefore Chitties on Contract rather than Chitty on Contracts. I will not read the form of the declaration which is there given as applicable to such a case as this, but it's clear. The framer of it didn't think it necessary to allege the delivery of a signed bill, etc. Then if you go down the page, just after the reference to Lord Justice Lindley in Reeves and Butcher, as has been pointed out, the result of our decision is that a solicitor has only 5 years and 11 months within which to sue for the amount of his bill of costs. I do not shrink from that result. It's no doubt a restriction imposed on him, but it is so imposed for the protection of his clients. And on the other hand, if the contention for the plaintiff were successful, it would follow that a solicitor might postpone for any time, subject of course to laches, the delivery of his bill of costs, and so prevent the statute from beginning to run. It was suggested that he must deliver it within a reasonable time, just as my learned friend has suggested that he should deliver an invoice within a reasonable time. But that suggestion is contrary to the whole scope of the statutes of limitation, which is that instead of it being left in case of delay to the court to say what is unreasonable delay has occurred, sometimes in cases in the Court of Chancery, a fixed period should be laid down by enactment. And Mrs. Justice Lambert, in the ICE, the ICE case, makes exactly the same point. Because it was argued there that the particular invoice, it wasn't really up to the plaintiff or the claimant to delay indefinitely the rendering of the invoice. There was an implied term that the invoice should be rendered within a reasonable time. And Mrs. Justice Lambert said that is exactly what the statute of limitations, exactly which is contrary to the spirit and letter of the statute of limitations. The court is not intended to indulge itself in satellite litigation, collateral litigation, on whether an invoice has or hasn't been delivered within a reasonable time. And in our case, in relation to the 19th of December or the 19th of December invoice, whether it was delivered at all. And then there is a reference to infringement of copyright, which is just worth bearing in mind. An author whose copyright is infringed is about 8 lines down, has an immediate right of action for infringement. But by section 24, it is provided that no proprietor of copyright in any book published after the passing of the Act shall maintain any action or suit in respect of any infringement of such copyright, unless he shall, before commencing such action or suit, have caused an entry to be made in the register, etc. I cannot see, if the contention of the plaintiff in this case is correct, why the author in the case of infringement should not wait for 20 years and then register his copyright and bring his action. For these reasons, I think the appeal should be dismissed. Now, we've turned quickly to Henry Boot and Alston for Lord Justice Dyson's reference. And it is worth just remembering that in that case, the reason why time did not begin to run when the services were performed was because payment, or rather the right to payment, depended upon the certification of the value of the services by a third-party engineer.
Yeah.
And it is very important to note that the amount that was payable was the amount which, in the opinion of the engineer, rightly or wrongly, was due for the work. And therefore it was not until, and could not be until, the certification of the value of the work by the engineer that any right to payment accrued. That is the distinction. And one sees, for example, at page 165, at letters A, it's in paragraph 24, but at letters A to B. Second line, thus what the engineer has to certify and Alston to pay is not the true final value of the work in fact done and materials in fact supplied, but what in the opinion of the engineer is due on the basis of the monthly statement. And then just above C, in my view, it's clear that Boot's entitlement to interim payment does not arise until the engineer issues his certificate. And one sees that again reflected in the case of Dunlop and Rankin. If you turn to page 166, in the same judgment of Lord Justice Dyson, where the same applied to an architect's certificate under a building contract. It's absolutely standard. As Lord Goddard, Chief Justice, said, until the architect has given a certificate, the builder has no right to receive any money from his employer by what I may call a drawing on account. He must get a certificate from the architect. Until the contractor can produce to the building owner a certificate, he cannot receive anything. And that's because in that case, the certificate was a condition precedent, 3 lines into paragraph 30. It's a condition precedent to the contractor's right to payment. Well, the rendering of an invoice and the expiry or expiration of 90 days in our case is not and has no resemblance to a condition precedent to the arising or the accrual of a right to payment.
So the invoice in this case is maybe a condition precedent to payment.
Yes.
But not to the right to payment.
Absolutely. That's exactly the
same distinction as between action and cause of action.
Yes, that's exactly right, my lord. That's how we put it anyway. Yes. And because we've looked at Lord Newburger's judgment in Legal Services Commission and Henthorne in Divider 16, I just remind you of this. The relevant provision is to be found at 252. It's Regulation 100, subparagraph 7 of the Civil Legal Aid General Regulations 1989, and subparagraph 8, where, after taxation or assessment, payments made under this regulation are found to exceed the final costs of the case, the solicitor or counsel, if any, shall on demand repay the balance due to the fund. This is where a barrister had been paid on account by the legal aid, by the Civil Legal Aid Service, I'll call it that. And the question was whether the barrister had been overpaid. And it was decided after assessment that the barrister had been overpaid, and a demand was made upon her for repayment. There was no criticism of her, I hasten to add. A demand was made upon her for repayment for the services, for the payment that she had received for services rendered. The services had been rendered long before, more than 6 years before the assessment and the demand and the claim for reimbursement. And so she said, supported by professional bodies, that the cause of action accrued when she had performed the services. And the court concluded, no, it was a condition precedent to the right of reimbursement that there should have been an assessment so that one could tell whether or not she had been overpaid. But it was also argued that it wasn't until a demand was made, because it says on demand repay the balance, it wasn't until a demand was made that there was an accrued cause of action. And the Master Rolls Lord Newburger, at paragraph 45, at the bottom of page 256, says, I turn to the argument based on authorities which are not concerned with the regulations, most notably General Electric in Halifax and Swansea City Council and Glass. In those two cases, the court held that there was a difference between the date the claim arose, in other words, the right to payment, and the date from which it was actionable, in other words, the right to enforce the right to payment. And then he says, as is clear from reading the speeches in General Electricity, that's the House of Lords case, of course, as well as the judgment in the Glass case, which is a Court of Appeal case, it's a question of construction of the relevant instrument, whether statute, regulations, rules, or contract, in each case, as to whether there is such a difference. So that distinction is not confined to statutory interpretation, claims under the Solicitors Act, or whatever it happens to be. It applies equally to contract. Then at paragraph 47, so as not to have to take you to the Glass case, the Glass case was where the council undertook costs of works of repair, which were really the responsibility of the occupier. And the council, having done the work, claimed those costs of repair from the occupier. In the Glass case, it was held that time started to run in respect of a claim against the occupier for the cost of works of repair carried out by the council under statute from the date on which the works were completed, and not from the date on which a notice required by the statute to be served before proceedings could be brought had been served. That was a case where the payment could only go one way. Just pausing there. This is a case where payment can only go one way, from CPA to CCI, namely to the council, and where the council would have known how much was due very shortly after the work was done at the latest. Likewise in our case. CCI will have known how much was due very shortly after it had done the work at the latest. But until service of the notice, substitute invoice, the occupier did not. Quite apart from turning on the statutory wording, the court was attracted by the argument that given that the council would always be the claimant, CCI would always be the claimant, it should not be able to delay time running against it by failing to serve the notice promptly. Ditto. Snap. And then at 49, I think my learned friend read this because my Lord Justice Jackson touched upon it, where Coburn is referred to at paragraphs 49 to 51. And I needn't go there. And so we can turn away from Lord Neuberger, and if we could now very quickly go, if we can, to the judgment, and I'm going to take this very swiftly, of Mrs. Justice Lambert in ICE, just to highlight passages which are relevant. This is in Divider 14. My learned friend was kind enough to take your lordship and your ladyships to this. The relevant invoice provision is at the foot of page 223, which of course is different from that in our case, but not materially different. And at paragraph 2, you see that ICE, I'll call them ICE if I may, would provide design services. And if one turns the page, one goes to paragraph 12, 225, the parties both agreed that the default position in an action for payment for work or services was that the cause of action arose at the time of completion of the work. The central question for the court was whether that default position had been displaced by the contractual terms set out. In the words of my learned friend this morning, the question is, was the rendering of an invoice and the expiration of 90 days thereafter a condition precedent to the accrual of a cause of action, or was it a mechanism for the administration of the contract? That is a perfectly apt question. Then the learned judge refers, as you see, at paragraphs 13 and thereafter, 13 to Coburn College, 15 to Henry Boot, 16 to Legal Services in Henthorne, and then she turned at paragraph 19 to whether or not the paragraph entitled Basis of Payment was a special clause. But her discussion and conclusions begin at paragraph 22. And we would echo what the learned judge said, line 4. A reasonable person in the position of the parties would have understood the words in the letter, in our case in the agreement, to be an agreement concerning only the process of billing and payment, namely the monthly provision of an invoice with payment within 30 days thereafter. The construction arises from a plain reading of the section of the letter under scrutiny. Further, and this is relevant to our case, in the context of the letter, it's common sense that both parties would have wished to reach some agreement concerning the billing and payment arrangements. The design work was not a single piece of work, but a rolling design project. Similarly, in our case, the work under this agreement, my own friend says 2 agreements, let's not quibble with that. The design work, or rather the work done under these agreements, was not a single piece of work, it was a rolling project. And turning the page to 229.
It might have been a cluster of projects, really, different projects.
Your ladyship is right, but it wouldn't ultimately make any difference to the principle. In these circumstances, some agreement concerning billing and payment would have been important, and on an objective construction of the intention of the parties, the payment terms of the letter reflect just such an agreement. And then, paragraph 23, which we echo, nothing in the language of the relevant paragraph viewed in isolation.
If one keeps with 22, you might say that there's a further echo in relation to budgeting constraints on EPIC.
You're absolutely right. Yes, I completely should have read that. You're absolutely right, my lord. And that is equally applicable. And then 23, nothing in the language of the relevant paragraph viewed in isolation or in the context of the letter as a whole therefore suggests that the parties were intending that ICE's entitlement to payment didn't arise when the work was done. And she explains why. And then at 24, she refers to the obiter statement of Lord Neuberger, clear words are needed if the timing of the accrual of the cause of action, etc., is to be displaced. Then she refers to Chitty, Lord Justice Chitty in Coburn, about certainty and stale claims. And then she says, 5 lines from the foot of paragraph 24, it seems to me that clear words are needed if the court is to construe an agreement between the parties in such a way as to give the creditor control over the start of the limitation period and or to avoid the courts becoming engaged in determining satellite issues which deprive the limitation provisions of their central purpose, certainty and the avoidance of stale claims. Such clear words do not appear in the letter. Then one goes on, if I may, to paragraph 27, where just en passant I mention.
Well, paragraph 25 is relevant to Mr. Coppell's surprising consequences submission.
Yes, it is, my lord. Yes,
It doesn't. I mean, it's we're by now rehearsing familiar territory, but that arose also in that case.
Yes, it did. Yes, it
Mr.
did.
Wright was making rather the same point, it seems to me.
It is absolutely right. You're absolutely right, my lord. I shouldn't take it so fast.
That's not an invitation to go slower.
No, no. Then you see the learned judge, she goes through all the right cases. She's got Boot, she's got Henthorne. She explains why in Henthorne and Boot there was a condition precedent to the right of action, or the right to payment rather, accruing. Then she refers to other cases. But, I should say that there is a reference to the reasonableness or the timing of, I think I've already done that. Sorry. It's paragraph 24. I rushed through it. Paragraph 24. Just after the reference to Lord Justice Chitty, she says, certainty in my emphasis of a fixed period during which a claim can be brought, and to avoid the courts becoming embroiled in collateral issues, such as in the context of Coburn, whether there was unreasonable delay in submitting a bill of costs, or in the context of the appeal, whether the invoice had in fact been delivered within a month of completion of the relevant work. If not, whether there was a reasonable explanation or excuse. I should have explained that the case before Mrs. Justice Lambert was actually an appeal from an earlier first instance judge. So that's that case. And then you go to Hurst and Dunbar, which is almost the last case, but not quite. Mr. Justice Eyre, who goes through all the law. This is a construction. This is what fell from his lips was obiter, I should mention, because he found that there was no contract by which the person who had done the construction work was to be paid. In fact, the person who'd done the construction work did it for his own purposes, but that's by the way. But at paragraph 95 at page 205, he refers to another case in the bundle, which I will take you to, but it's referred to here, in Burst Construction. This is on the Judge Coulson, as he then was. The date of the accrual of a cause of action for sums due under a contract for worker services will usually depend on the terms of the contract itself. However, it's important to note that starting point for any consideration of this question is the established principle that in the absence of any contractual provision to the contrary, a cause of action for payment for work performed, services provided, will accrue when that work or those services have been performed or provided. Then you have Coburn, and then he goes through all the cases, and he says at paragraph 102, which is important, it is necessary to distinguish between A, contractual terms or statutory provisions, such as that in Henry Boot, which are conditions precedent to a right to payment arising, and B, provisions which impose conditions for the bringing of proceedings, such as that upon which my Lord has referred, to which my Lord has referred, and which are concerned with limiting the right to bring an action to enforce an entitlement to payment. The former affect the date on which the cause of action accrues, whereas the latter have no impact on that date, even though they may mean that the period in which a potential claimant can commence proceedings is less than the full limitation period running from the date of accrual of the cause of action. Then at 107, he refers to Mrs. Justice Lambert's further distinction between a cause of action and an agreement or term concerning only the process of billing and payment. And then he says, and this is not uninteresting to your lordship and to your ladyships, at 112, this is in relation to whether clear words are needed, as referred to by Lord Newburger, and indeed later by Mrs. Justice Lambert. Mr. Justice Eyre says about 10 lines down, even if that approach means that there can no longer be a formal requirement for clear words, the practical result of the construction exercise is likely to be unaltered. This is because an interpretation which would give a potential creditor control over when time runs for bringing proceedings to recover the debt in question would be one which is unlikely to have been agreed as a matter of commercial common sense, and one which would also be incompatible with the purpose of the limitation regime. That would be an unusual provision to include in a contract. As a result, when having regard to the context in which the contract is being construed, the court is unlikely to conclude, in the absence of clear words, that a contract can properly be construed as giving the creditor control over the date at which time begins to run for limitation purposes. That follows from the assessment that if the parties intended such a departure from the norm, they are likely to have used clear words to give effect to that intention, and the absence of such words is an indication that there was no such intention.
It was rather the point that my lord put, I think, some time ago.
It was, right at the beginning. Absolutely. And this has just reminded me that there is one thing in the judgment of Mrs. Justice Lambert, which I might have rushed over. Forgive me. Might be Kirsten Dunbar. No, it doesn't matter. I think it was what I was referring to in paragraph 107 of Mr. Justice Eyre's judgment in when he refers to IC, the distinction concerning only billing, only the process of billing and payment, in other words, the mode of payment. And the reason I mention this is I'm going to take you out of sequence in a sense. Your Lordship and your Ladyship will recall that we are also engaged partly on the undertaking, not in relation to future work at all, as I understand it, and I think that's now clear and clarified by my learned friend, only in relation to the work that had been undertaken and was the subject matter of the invoices. In other words, that's what my learned friend had said, that I think he...
No, I think he said the opposite, which is what confused me. I thought that the case that you had to meet was that the invoices were in some way subsumed in the undertaking, and therefore the limitation period was extended further by the undertaking to the 31st of December. But as I understand what Mr. Koppel was saying, was that his primary case was that the invoices are not covered by the undertaking, but the undertaking encompasses other work which had been done for which no invoice had been delivered. Yes, I was a bit startled too, Mr. Keeley. For which no invoice had been delivered, but for which your clients had agreed they would make payment of a sum certain by the end of December 2013.
Gosh. Well, right, well, that is a new case for me, but it doesn't matter.
Am I right, Mr. Koppel?
Your Ladyship is correct.
Yes, I thought it was.
Well, then my ears were not sufficiently attuned. Well, it doesn't really matter. If that is my learned friend's case, it's certainly not a case that I thought understood before had ever been made against me. But again, my memory may not be terribly reliable on these things. One needs to go to the if this case is going to be made, one needs to go firstly to the undertaking, secondly the judge's judgment, but perhaps first I will take you, in fact, to my learned friend's skeleton below, which is in the supplemental appeal bundle. Because this is the case I thought I had to meet. It is in paragraph 40, which is at page 21 of the paper bundle, at page 24 of the electronic bundle.
I've got it. Page 23.
23.
Thank you.
And if one goes to page 24, this is paragraph 3 of paragraph 40. the undertaking and commitment given by CPA through its executive board chairman makes clear that a payment which included discharging all the existing invoices,
Yes, that's why I said what I said.
yes, was to be made by the 31st of December 2013. And then he doesn't like what Mr. Webber says. Mr. Webber is my instructing solicitor. And he goes to, and he says that's a thoroughly bad point. He says the opening words of the document record, and it's worth recording it, in accordance with the agreement made between CPA and CCI for conducting studies, research and consultations, whereas the said company has performed consultations and multiple studies in this field. This, my lady, is a document dated or delivered on the 2nd of October. The association undertakes to pay. We will have a look at the actual undertaking in a second. But this is what my learned friend says it means. In other words, it is recording the making of the first agreement as alleged by CCI. It is recording the doing of work under that agreement as alleged by CCI. And it is recording how CPA is to pay CCI for having done its work. All the past tenses, but it is very important to note that what it records, according to my learned friend, is how CCI is to pay. It's all to do with the mechanism of payment, just as Mrs. Justice Lambert explained the invoicing provision with which she was concerned in ICE. It is simply recording a mode by which CPA would discharge its liabilities under the first agreement for the work so far carried out, i.e. by making a payment of tens of millions of dollars to the account in the name of Mr. Pincioni. Mr. Webber's analysis for the undertaking the second witness is no better than his original one. But at least Mr. Webber's useless analysis has elicited and exposed this case. And I have to say, my lord, my ladies, I don't disagree with a word. It is simply recording a mode, in other words, a mechanism, by which CPA would discharge what? Its liabilities. In other words, there was already an accrued right to payment, otherwise there wouldn't be a liability to be discharged. For the work so far carried out, not for the work to be carried out in the future.
Yes, I think we've got that.
Right, okay, sorry. The undertaking itself, of course, you will see in the, one should go to the pleading, which is what I've been guided by mainly in this case, which is that divider, one can go to the points of claim, the particular claim, to page 103. So that you don't get irritated by the tone of my voice, if your lordship and your ladships could look at line 3 of paragraph 10 at 103. Paragraph 10. Under this undertaking, the defendant recognised that the claimant had performed consultations. And that's right. So the case that I've always thought I was meeting, it was developed in oral argument by my learned friend, I confess, before Mr. Justice Jacobs. But he said, and this is worth noting, in Divider 7, in his judgment, at page
But it's para 95.
it is 95.
Page
And it's
89.
also 93, my lady, but it's also in 95. In 93, one possibility is that as both the terms of the undertaking and paragraph 10 of the article of claim indicate, the amounts were payable in respect of work that had already been carried out. And then another possibility is 94, it was unrelated to past work, or work to be carried out prior to. Then 95, the case in fact advanced by CCI at the hearing was that neither of those was correct, had a mixed character, and it was also a prepayment for future work. But we know, my lady, and this we do insist upon, permission to appeal has been refused in respect of any future work. It's not simply on the basis of no repudiatory breach claim was ever made. It's only in relation to past work that permission has been granted. And moreover, only in relation to past work in relation to the invoices, albeit under the undertaking. And then at 96, the judge says, I'm doubtful as to whether this way, that's the last way, of putting the case is consistent with the pleaded case. I don't consider that there's anything in the claim form, particularly the claim suggests that the 43 odd million represented a part payment for invoiced amounts and a prepayment of uninvoiced amounts in respect of work to be carried out in the future. And that is the basis upon which he proceeds. And when he talks later about the absence of consideration for future work or for payment for future work, I mean, that's an irrelevance. It features in my learned friend's skeleton argument for this appeal, but really it shouldn't appear at all because no permission has been given in relation to future work, and the argument in relation to a total failure of consideration was purely in respect of the future work for which my learned friend seemed at one stage to be saying that he was entitled to payment for. As one sees reflected in paragraph 99.
But the crux of the judge's judgment, of course, in relation to that is at paragraph 98.
Yes.
31st of December is the time for payment, but it doesn't help any more than the 90-day provision in the original invoice.
Exactly so. Yes, it's time barred. Because, as my learned friend in fact asserted, all that the payment date in the undertaking was concerned with was the mode or mechanism of payment for a liability that already had accrued. So, I mean, that's the end of that point, if I can be so caustic. And so, my lord, my ladies, I mean, I have too many notes, but you have everything in writing. I should just mention that we are still taking the point, albeit by, I believe, by respondent's notice, that the second agreement was not something that featured in the claim form.
This is respondent's notice A.
Yes, yes.
We can forget about respondent's notice B.
Oh, right. Yes, yes. You can forget about, because it's been accepted that quantum merit is not being pursued.
So B falls away, but you'd like to address us just on A.
Just very briefly.
Was it argued below, Mr. Keeley, the point about the non-pleading of in the claim form? It was.
Yes, I failed on that. My point was very simple. It remains very simple. It's either simply wrong or simply right, which is that this oral agreement, which is a further agreement, you can describe it as a Muscovite agreement or a Zanzibar agreement. You can describe it as an extension to the first agreement. It doesn't actually change the character or the nature of the agreement.
It's a fresh agreement relating to different services.
Exactly.
And it's not pleaded.
And it's not pleaded.
No.
And so we said it only crept in, I don't mean that rudely, it crept in with aplomb into the particulars of the claim in 2021, I think, and wasn't originally pleaded in the claim form. It wasn't something that we predicted. It's right, as my learned friend, the invoices are not necessarily confined to asthma or anything like that, but then the original agreement's not confined to asthma. And so the oral agreement is a new claim, a new cause of action, and is time barred for that reason.
Unless those invoices come in again under the undertaking. If those invoices are encompassed by the undertaking, they don't need the second agreement. If they're not, then they do, which is one of the reasons why I was pressing Mr. Coppell as to whether the invoices were independent of the undertaking.
Yes. Well,
speaking for myself, I think there's more in the point, perhaps, than the judge did.
Well, we think there's more in the point than the judge did, but then
May not matter.
We would.
Could you just remind us where the judge deals with this?
Yes, of course. It's divider 7.
Yes, I've got the judgment, just which paragraph?
102, my lord, I think.
This is the freestanding limitation point. Yes, thank you.
Yes. Can I just mention?
We're not concerned with the title to sue argument.
No.
That's not.
No, that's the bad argument.
Yes. Okay.
My Lord began this appeal by saying that this wasn't the first case in which there's been an issue as to what permission to appeal has been granted in respect of. At the time that permission was granted or refused by Mr. Justice Jacobs, as I recall, there were no grounds of appeal.
Could we just walk through this then? The hearing we see took place on the 22nd of February. The judgment is dated the 3rd of March. You may have had it in draft. I don't know. Yes.
Yes, we would have had it.
So the judge turned this round very swiftly.
Yes.
And we then have an order which is dated the 14th of March. And the refusal of permission and the grant of permission is contained in that order. Right, so it all happens within a few days.
Yes.
Was the decision in relation to permission to appeal taken on the basis of paper submissions, or was there a hearing? Now, I know there was a hearing because there was one about costs.
There was a hearing.
The transcript that we've got appears to relate at a quick look only to costs. That was the 22nd of February.
Yes.
Sorry, there's another transcript which relates to a costs decision.
Yes.
It's the consequentials hearing, page 117 in the bundle on the 14th of March. Right? So that was the date of the order itself, and just looking to see what's.
That's pure costs.
That's pure costs. So just before you make your points about this, it would help us, I think, to understand what the sequence of events was that led to permission to appeal being considered and then granted in part.
Yes, there was an oral hearing on permission to appeal. And indeed, one sees that reflected at page 68 of the bundle, divider 6.
As part of the order itself?
Yes.
Yes.
And paragraphs 8 and 9 are those on appeal.
That's right.
And
presumably people came along with documents dealing with consequential issues on that date.
Yes, indeed, my Lord.
And one of those will have been PTA.
But one of those documents, which, listen, I'm not criticising anyone, it should have been, in accordance with the Commercial Court Guide, there should have been grounds of appeal. But there were none. There was none. No grounds of appeal were put before Mr. Justice Jacobs.
So, in effect, the drafting of the grounds of appeal forms part of the judge's order, paragraphs 8 and 9 as you've shown us.
Well, paragraphs 8 and 9 were ordered without having seen the grounds of appeal.
Yes, but when was this order dated as it is? The
17th of March, I think.
It's the 14th of March, and it's sealed on the 17th of
Yes.
March, so the order didn't take long to draw up either.
No.
And I mean, we just don't have the materials, which obviously you did have, as to what the judge was shown, what he said and why, and how they then came to be represented in paragraphs 8 and 9. Could you help us?
You don't have the transcript, I'm afraid, and nor do I.
No, it doesn't matter, but just in a sense, in a nutshell, the judge heard oral submissions on that matter.
Yes.
No doubt reflecting somewhat what was said in any written remarks, and that's the product, an order no doubt drafted by counsel and presented to the judge and agreed by him.
That's right, I think. Yes, that's right. Mr. Popple.
Right. Okay. Now, so sorry, that represents a sort of baseline for you to say whatever you want to say.
Right. The grounds of appeal came later. As I say, I'm emphasising, I'm not criticising, just a fact in this case. And the grounds of appeal
which we
And of
which
course-
we have at page 12 of the core bundle.
Yes, and thank you. Then you have the reasons given, my lord, by Mr. Justice.
Forgive me, I'm sorry.
No, sorry, I was rattling on without looking up. At divider 14, at page 120 or 122, you have the reasons given by Mr. Justice Jacobs
Yes.
for granting and refusing permission.
Well, that had-
What's the date of that?
It must be the same date as you did the order, isn't it? Would that be the 14th? You normally fill the two
think
forms
it
in at
came
the same
after,
time.
Actually,
Oh,
I think it, as I recall, it came after. Was it the same day?
well, it doesn't really add anything.
What date is that? 14th. It was the same day, the 14th of March.
that's what you'd expect.
Yes.
So, PTA allow refusal, same date. Right, no formulated grounds of appeal then in existence. Grounds of appeal which you then taken us to in the bundle, which is part of the appellant's notice and is filed on the 4th of April. The next port of call is perhaps?
4th of April? Yes, that's right, my lord.
And there you have immediately a situation having arisen where some grounds have been allowed,
Yes.
some grounds have not been allowed but are now going to be renewed, which again raises to my mind an issue about practice in terms of granting permission to appeal at trial.
Yes.
Okay, well anyhow, you've got to the point where you've now got your grounds of appeal, some with permission, some not with permission.
The second ground was refused permission
Justice Mail refused and re-refused the second ground.
and re-refused and re-refused. Yes. And the first ground is the ground that is set out at page 12, I think, 12 of the paper bundle. And I know it's a technical point, but I'm going to take it nevertheless for my sins. The first ground is confined to invoices. And I say that for the very simple reason that the references to the judgment are to paragraphs 63 through to 72. And paragraphs 63 through to 72 are concerned exclusively with the claim under and pursuant to the invoices. And one sees that at the top of page 80 under discussion, the claim in respect of the invoices rendered, which the discussion begins at paragraph 56 and ends at paragraph 73. And the claim under the undertaking only comes at the heading of paragraph 74.
Right, so that's the point on that.
That's the point on that. Now, if these grounds had been before the judge in the first instance, he would have had the opportunity, and indeed Lord Justice Males had the opportunity, of saying that ground 2, second ground, was refused consistently and persistently, and Lord Justice Males could and should have said, in our respectful submission, but the trouble is all this is done on paper and it's not done sufficiently well before the judge at first instance, for the judge at first instance looking at the document actually to give permission or not give permission. He didn't have these grounds. And the first ground is confined to the invoices. It does not extend to a claim additional or alternative or whatever under the undertaking. Now, it may not matter, I say that optimistically, but you don't really want to take that from me. In relation to the undertaking, I've made my submissions. But it is nonetheless, if I were saying something about the practical value of how matters should be dealt with by the commercial court and subsequently, as necessary, by the Court of Appeal, but by the commercial court, it's absolutely imperative that the first instance judge who is considering this should have, as the commercial court guide requires, the grounds of appeal before them, so that they know exactly what ground they have, what it says, and for what they are giving or refusing permission.
Perhaps particularly in a case where permission is being part granted.
Yes.
One of the things I'm going to mention it now rather than at the end, would ask both parties to do, please, and I'm not asking for elaborate bills of costs, just headline figures, is to know what this appeal has cost both sides and also what the costs before the judge were.
We have the schedules of costs already available, so they can be.
Well, if there are, I know I've seen one schedule from the appellants. Thank you, but
not from us, possibly.
Because another thing to be considered surely is that the I mean, this may not be a case in which the respondent to an appeal is destitute, but it's a consideration that must be taken into account is what the overall cost of an exercise is going to be.
Yes.
I mean, at the moment, we only have the judge's, I may say so, very careful judgment and his reasons for allowing permission to appeal against his central decision, which is that an appeal has a real prospect of success. There's no indication either judge thought that. I'm sure he conscientiously did.
Yes, yes, yes.
All right, so we'll have, if nothing else, ballpark figures, please, below the judge and here.
Certainly, my lord. Can I just have a word with Laing? My ladies, my lord, those are my submissions.
Thank you very much, Mr. Keeling. Yes, Mr. Koppel.
Just 2 points of reply.
Thank you.
The first is Mr. Keeley's submission that a right to payment of a debt gives rise to a cause of action, the way that he put it. That is not correct. The debt, the right to payment of the debt, is a necessary but not sufficient condition for the accrual of a cause of action. It's a necessary but not sufficient condition for the accrual of a cause of action. In a debt arising under a contract, for a cause of action to arise on that debt, there must have been a failure to pay an amount as required by the contract. What must the supplier, we ask ourselves, plead in particulars of claim to have a viable debt claim? The answer is, must plead the contract, must plead provision of the service, must plead failure to pay as required by the contract. 1, 2, 3. To plead only 1 and 2, that is contract plus provision of the service, but not 3, that is failure to pay, does not make a viable debt claim. There is no cause of action. The third allegation, non-payment, is not a defence. It's not a defence allegation. In other words, in a debt claim, the supplier cannot, following the Judicature Acts, simply plead the contract and the provision of the service to found a claim in debt. Non-payment is also required. And since non-payment is also required, one has to identify the date, if any, prescribed by the contract for that payment. A learned friend submits that allegations 1 and 2 suffice, but that fails to appreciate that things have progressed with the Judicature Acts. And we see that in fact, in the passages that he cited from College and Coburn, sorry to keep on going back to that, or Coburn and College. If we go to the second judgment, so we are looking at paper 137, electronic 139. It's the judgment of Lord Justice Lopez. And it's the passage which my learned friend read out that starts halfway down the page, where he says, it is useful for the purposes of the present case to consider what, under the old rules of pleading before the Judicature Act, the course of pleading in such an action would have been. Not that they are, would have been. Solicitor would have sued in debitatis assumpsi, or on a common money count for work and labour. That's not a cause of action, that's a count. If the defendant had pleaded merely never indebted, and the case had gone to trial on those pleadings, the cause of action would have been said to have arisen as soon as the work is done. So this is pre-Judicature Act. If the defendant intended to raise any defence on the ground of non-delivery of a signed bill, he must plead that such a bill had not been delivered. Delivery of the bill formed no part of the plaintiff's cause of action, formed, i.e. pre-1873. Upon proof that work had been done, prima facie, the plaintiff was entitled to recover. It was for the defendant to set up by his pleading that no bill had been delivered. That represented the position pre-Judicature Acts, but it doesn't represent the position following 1873. And that's made clear by Lord Esher in the previous page, 136 of the print, 138 electronic, where again at about the halfway mark, he says, he refers to the judgment of his brother judge, and he says, applying that to a case like the present, when the plaintiff had completed the work under the old course of pleading, alluded to by my brother Lopez, he could have brought his action declaring the money payable for work and labour done at the request of the defendant. And if the defendant made no answer to that claim, he would have been entitled to recover. So he didn't have to say, I haven't been paid. It was simply enough to say, contract, I did the work, I want the money. And the defendant could not have demurred to the plaintiff's declaration, which would have shown a perfectly good cause of action, and unless the defendant set up something to defeat the claim, the action would have been maintainable. Therefore, as soon as the solicitor had done the work, he could have maintained his cause of action for work and labour. The defendant might plead that no bill of costs had been delivered, but that would only be by way of answer to a case which constituted a good cause of action. The question post-1873 is to ask, what must the plaintiff allege in the statement of claim that, if admitted, or treated as admitted, would entitle the plaintiff to the relief claimed?
Mr. Coppell, if there was a sea change with the bringing in of the Judicature Acts, then both the judgments you've just quoted would not have gone on to say, for those reasons, I think the cause of action arose the moment that the work was completed.
My lady, that's...
They would have said, however, there's been a sea change since the coming into force of the Judicature Acts, and you now need to plead that the money hasn't been paid.
My lady, in this case, in Coburn and College, the moment for payment and the completion of the work were coincident. They were coincident because there was no words to the contrary. And that, my lady, is why the Master of the Rolls opened his judgment in the way that he did, with that stark choice between the two, where he says, it is admitted that if the cause of this action in this case must be considered to have arisen when the work was completed, the defendant must succeed. That's one option. The other option, but if it's considered as having arisen only at the expiration of the period of 1 month from the delivery of the signed bill, the plaintiff must succeed. And the difference with our case here is that there are words to the contrary. Mr. Keeley says there is a distinction between the accrual of the cause of action and the right to bring an action. Acknowledge, happy with that distinction, but it doesn't have the effect submitted by Mr. Keeley. an action is brought upon a cause of action, or indeed more than one cause of action, that's what one does. And it is certainly possible for a statutory provision to preclude a person who has a cause of action bringing an action on that cause of action, whether for a period, as in college, Coburn, or absolutely. And so too, if the parties make it clear in their contract, they can do the same. And all of the various authorities we've looked at where that was the case involved examples of that. The task for the court and the court below here is one of interpretation, contractual interpretation. The cause of action for non-payment of the contract sum is a breach of contract. Cause of action is not the existence of a debt. The claim on that cause of action is a debt claim, meaning that the claimant does not have to prove damage to make good the cause of action. But for there to be a cause of action, the claimant must still prove that the defendant has not done what the defendant was contractually required to do. Must prove a breach of the agreement. When we turn to the agreement again, there's words we've looked at.
I'm sorry to interrupt you.
111.
Scopel, do you mind if, before we do that, I'm just trying to grasp the point that you're making on Coburn and College and the 3 steps. Could we look at the bottom of page 137 in the judgment of Lord Justice Lopez onto the top of 138? Now, I want to leave open the possibility that I've simply missed the point. But you see where he says rhetorically at the bottom 4 lines, how then can it be said that the cause of action is not complete before the delivery of a signed bill? Well, one thing we can be sure about is he's talking about post-Judicature Act.
Correct.
We moved away from forays into the old world.
Yep.
Continuing, if that were so, it would have been necessary for the plaintiff to allege in his declaration that such a bill had been delivered. No one ever heard of a declaration in such a form. How does that...
Well,
can you just explain how that sits with what you've just been telling us?
the declaration is a reference to the old form of action, because that's what one would seek, is a declaration. Your Lordship, we agree with, that he's slipped into post-Judicature Act.
Yes.
And what's being said is that the moment for payment and the completion of the work were coincident. They were at the same time. There was nothing to displace that. There were no words to displace that.
Well, I'd understood that he was making a general proposition, saying that you don't have to prove that there's been a failure to pay as part of your pleadings in a completely accrued cause of action. It may have the facts be right or wrong, but that legally speaking, the declaration that you demanded or not being paid is not necessary.
But to have a cause of action on the contract and make a claim in debt, i.e. we've suffered no damage, but the money is outstanding, requires there to have been a payment that was not met.
Well, implicitly, maybe, but all you need to say is, I've done the work, this amount is due, and it remains due. Is and has been due since such and such a date.
I mean, I don't want to as it were, go over old ground again, but at the moment I just register the fact that I'm finding it very hard to park your submission and Lord Justice Lopez's statement in the same parking place.
Well, my Lord, I mean, I feel sure won't get better with repetition by me.
No,
I think the bench has my point.
Yes. Well, now, were we still on the first point in reply?
We are. I'm almost there.
Thank you.
Just to say, if we look at the 2 paragraphs at page 111 and ask ourselves what it is that the respondent was required to do, the answer is it was required to pay CCI within 90 days of the submission of the invoice. It doesn't say that CCI shall not bring an action upon a cause of action upon the expiration of 90 days from the submission of the invoice. And for my learned friend to read it that way is really to rewrite what the parties had agreed upon. And there's no getting round that. And we say that's really the mistake that the judge made below. We look at the provision and ask what it is that the parties required of each other. And in terms of a claim being brought by my client, what it is that they need to allege in order to get that claim off the ground. And they need to allege that there was a contract, they did the work under the contract, as a result of that, there was a debt, and the time for payment of that debt expired without there having been full payment. That's what gives rise to the claim in debt. So that's the first point. Second reply point refers to, well, it's the undertaking in my learned friend's respondent's notice. If we return to the particulars of claim, paragraph 10, page 103, paper 105, electronic, that makes it clear that the undertaking to pay is in respect of work that had already been carried out. It says that, as does paragraph 4 of the claim form. So the undertaking allegation all relates to work done. And again, it's in a sense the same point that I've just made. What the particulars of claim allege is that the undertaking that the respondent agreed, or by the undertaking, the respondent agreed to pay 161 odd million Saudi riyals by the 31st of December 2013, if and only if the respondent didn't pay by that day, did the respondent fail to meet its obligation in the undertaking, which gives rise to the cause of action. The ground for permission, for which permission was given, was not limited to the invoiced amounts. And we can see that in the order itself of Mr. Justice Jacobs. It's paragraph 8, page 69 paper, page 71 electronic. It's the last whole sentence where he says, whether invoiced as set out in paragraph 7 of the particulars of claim or encompassed within the undertaking pleaded in paragraph 10. And indeed, you see a reference to that in the reasons for refusing. We can, if you like, my ladies and lords, set out the whole sequence of what took place in relation to the giving of permission, but my recollection of what took place is that when the judge had delivered a draft judgment, he said he'd like to hear the parties in relation to the order and also consequential, such as costs, including permission to appeal. It is quite correct what my learned friend said. I did not have written grounds of appeal, which I put before the judge, but I did make those grounds orally. And that's why there and then he gave permission, and he gave permission in the way that he did. So I tried to get more by way of permission than I actually got. He gave me some of it, but not all of it. And that's, in a sense, how it passed together with, obviously, the order for cost together with a payment on account and what have you. So the transcript that you have is only a bit relating to cost. It doesn't relate to the argumentation over permission to appeal. Unless there's anything further, I won't trouble your ladyship and lordship.
Thank you very much, Mr. Coffey. Very well. Well, we'll take time to consider our judgments and send them to the parties' representatives in the normal way, with a view to you please making any editorial corrections and agreeing an order consequent upon our decision. In the meantime, would you, as soon as conveniently possible, send to my clerk the global costs figures that I spoke about?
Here and below.
Sorry?
Here and below.
Here and below, to my clerk, please, as soon as you can conveniently. If it would be most convenient, I think, certainly, so that everybody knows what's going on. If you please send in a joint page telling me, my colleagues, what they amount to, and we'll do our best to let you have our decision as soon as we possibly can. Thank you very much indeed.